Good morning. My name is Patricia Roberts, and I have the privilege of serving as the Dean of St. Mary's University School of Law. I want to welcome you to the Linda and David Schlueter first-year moot court competition final round. We had intended for this to be live streamed, but we're going to record it instead because, as has happened so many times this year, we are experiencing technical difficulties. So please accept my apologies. I want to first give appreciation to several groups who have made today possible. First, of course, I would like to thank the Fourth Court of Appeals, the Chief Justice and her fellow justices, and all women court that continues to be reflective of St. Mary's, with 5 of its 7 members being alumni, and all 7 members continuing to support our students, including annually and most recently at the Women in Law Leadership Reception. Our students are among the very few in the nation who annually have the opportunity to argue in front of and receive feedback from one of the state's intermediate appellate courts, a privilege they have enjoyed for more than 10 years. I also want to thank the Clerk of Court, Michael Cruz, who graciously is handling our final round competition as court is actually in session with all of the requirements that such a level of significance warrants. And in this particular year, he has to do it on Zoom. I want to also thank our 1L instructors in our LCAP program. They've spent the entire year working with each of our 1Ls in honing their legal writing and practicing their oral advocacy skills. At the end of this demanding year, they share our pride in all of our 1L students for the commitment and skills you brought to your brief writing and this moot court competition. It would be remiss of me if I didn't thank all of the attorneys and upper level students who judged competition rounds to get us to this final round. No advocacy competition can happen without impartial and skilled judges and brief reviewers. Many of our volunteer judges, both the attorneys and the students, worked not only on this competition, but on a number of the countless tournaments hosted virtually by our advocacy program this year. And those efforts were led by our Board of Advocates, a student group that is chaired by Elizabeth Dugan, and the co-tournament directors for this tournament, Meredith Knox and Noah Warren. The Board of Advocates led the way in organizing and staffing the nation's virtual advocacy competitions this year, which often required around-the-clock work in the Board of Advocates Zoom headquarters and training, judging, and staffing hundreds of advocacy rounds flawlessly. Their efforts have greatly enhanced the reputation of the advocacy program, while many of their members simultaneously competed themselves. To Linda and David Schlueter, we are so grateful that Professor Schlueter and his wife recognize the importance of the skills taught in our LCAP program and established the funding to support this 1L competition in 2010, which has become a rite of passage at the conclusion of the 1L year and an opportunity for our students to stretch themselves as newly trained advocates. We're also grateful to the director of our LCAP program, Afton Cavanaugh, and our hardy director of advocacy, AJ Belita DeLuna, Coach Ricky Poole, in charge of our moot court teams, and all of our dedicated coaches whose efforts result in the continued success and national ranking of our advocacy program. We're also grateful to our IT department, without whom none of these competitions could have happened this year, including this one. So congratulations to our final 4 advocates and good luck as you compete this morning. Thank you.
Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good morning, everyone. The court will now call Supreme Court docket number 20-165, Sung-Woo Cho, also known as Eric Cho, versus State. Announcements, please.
Good morning. My name is Brenda Marie-Chalad, and I am Speaker 1 for petitioner.
My name is Josue Barron, and I will be speaker 2 for petitioner.
Petitioner stands ready.
Chief Justice Martinez, my name is Catherine Cantu, and I will be speaking first on behalf of the respondent and team number 152.
Chief Justice Martinez, my name is Daisy Ramirez, and I will be speaking second on behalf of the respondent, the United States of America. Respondent stands ready.
Good morning. Counsel for the petitioners, you may proceed.
Chief Justice, Associate Justices, and may it please the court. My name is Brenda Marie Chalad, and I, along with my co-counsel, Mr. Josue Barron, represent the petitioner, Eric Cho. Your Honor, at this time, I respectfully request 2 minutes for rebuttal. Thank you.
So approved.
Your Honor, this case is about an undocumented individual who entered the United States as a child and is now being targeted and criminalized by the very country he calls home. There are 2 issues before the court today, and I will be addressing the first, which is that Eric Cho is included in the term the people and therefore merit Second Amendment protection. Then my co-counsel will demonstrate that the statute merits and fails strict scrutiny analysis. This court should reverse the decision of the 15th Circuit for the following 2 salient reasons. The first is that Eric Cho has sufficient connections to the country and is therefore among the people. The second is that the Second Amendment is like the First and Fourth Amendments, which use the term the people and already extend protection to undocumented individuals. Turning to my first point, that Eric Cho demonstrates sufficient connections to the country. The Second Amendment provides that it is the right of the people to keep and bear arms, and that this right shall not be infringed. This court in District of Columbia versus Heller held that this right meant that an individual could possess a firearm for self-defense and defense of the home. This court also determined who this right belongs to. This court adopted the standard in United States versus Verdugo Urquidez, which held that the people refers to the national community or to those who have sufficient connections. To determine whether a person has sufficient connections, a person must demonstrate both voluntary presence and societal obligation. In creating this test, this court deemed undocumented status as an irrelevant factor because an undocumented person like Cho can easily pass this test. And he does pass this test. Cho has demonstrated voluntary presence in that he entered the United States as a child, and he made the decision to remain in the United States. In fact, he made several efforts to ensure his stay in the United States, which includes applying for DACA and being granted this protection.
Excuse me, counsel, are you attacking the statute on its face or as applied to Mr. Cho only?
Your Honor, this statute on its face is unconstitutional, but today we're arguing before the court of an as-applied challenge. We have briefed the on its face challenge. However, we are arguing on the behalf of Cho today. However, this extends to any undocumented person like Cho. And any person like Cho has sufficient connections and therefore are considered among the people. Cho has societal obligations in that he attended public high school, a public college, and he's currently enrolled as a law student. He also established societal obligations in that he applied for permanent residency upon marriage to a United States citizen. In United States versus Mesa Rodriguez, the 7th Circuit held that Mesa Rodriguez, a Mexican citizen, had sufficient connections to the country and therefore could invoke Second Amendment protection. Mesa Rodriguez had lived his entire life in the United States. He had developed relationships with family and friends, and he had obtained various jobs. The 7th Circuit held that this was enough to be considered among the people. Furthermore, in Ibrahim versus Department of Homeland Security, the 9th Circuit held that Ibrahim, who was a citizen of Malaysia, had enough sufficient connections to invoke First Amendment protection. She was considered among the people because she was living in the United States and studying to receive her PhD degree. Furthermore,
Counselor, I have a question for you. What authority do you rely on to interpret the use of the people in the Second Amendment How do you place that in context with other US Supreme Court opinions that interpret the term "the people" in the context of other amendments?
Your Honor, in United States versus Verdugo Urquidez, this court created the test for the people for a Fourth Amendment problem. So the defendant before the court in that case was an undocumented individual. This court created that test for the purpose of applying it whenever an undocumented individual is before the court and the court needs to determine who is among the people. And since that ruling, lower courts have interpreted to mean the people in the Second and Fourth Amendments and the First Amendment. Furthermore, in District of Columbia versus Heller, this court deemed the term "the people" a term of art, which has similar meanings in the First, Second, and Fourth Amendments. And this brings me to my second point. In Mesa Rodriguez, the court held that the term "the people" is must have similar meanings within the Bill of Rights, because the Bill of Rights is like a package. So what the people means in one amendment must mean the same in the First and Fourth Amendments. Furthermore, Justice Scalia wrote in Heller that the Second Amendment is like the First and Fourth Amendments, and that they're all pre-existing rights. This means that the Constitution does not grant this right, they merely protect these rights. Courts have determined who receives First and Fourth Amendments by way of the sufficient connections test. The Verdugo Urquidez court explicitly stated that as a term of art, the people refers to all of those who have sufficient connections to the country. In the First Amendment context, the sufficient connections test was applied to Ibrahim in Ibrahim versus Department of Homeland Security, and she was able to invoke First Amendment protection. She had sufficient connections because she was living and studying in the United States. In the Fourth Amendment context, the Fifth Circuit applied the sufficient connections test to Martinez Agüero, and they found that the defendant, who was a Mexican citizen, had sufficient connections because her frequent crossing of the border meant that she had to accept the laws of the United States and of immigration and follow them. Therefore, accepting the laws and following them within the United States is enough to be considered among the people. Furthermore, all of these cases demonstrate that being an undocumented person in the United States does not exclude a person from Second Amendment, First Amendment, or Fourth Amendment protection. It's not a pro se exclusion. And this court, in adopting this test, made this avenue for undocumented individuals to receive Second Amendment protection. Furthermore, the Fourth Amendment has extended to undocumented individuals in INS versus Lopez Mendoza. In that case, this court acknowledged that undocumented people do have a constitutional right for protection within the Fourth Amendment. Because the test for sufficient connections should be applied whenever the people is in question, we ask this court to adopt this standard and to apply it to Cho. And when it is applied to Cho, it is obvious that Cho has more than sufficient connections to be considered among the people. And it is for these reasons we ask this court to find for petitioner and to reverse the decision of the lower court. Thank you.
Good morning, Mr. Barron. You may proceed.
Chief Justice, Associate Justices, and may it please the court. My name is Josue Barron, and I will be continuing arguments on behalf of the petitioner, Mr. Eric Cho, regarding the scrutiny analysis in the case at bar. Your Honors, this case is about a law that renders law-abiding, responsible individuals defenseless within the sanctity of their own homes, in which we ask this court to reverse the decision of the United States Court of Appeals for the 15th Circuit for the following two reasons. First, that the statute places a severe burden on the core right of the Second Amendment and thus merits strict scrutiny. And second, that under a strict scrutiny analysis, the statute fails to be the least restrictive means and is unconstitutional. And on to the first area of analysis, the severe burden. Your Honors, the last time this court addressed a Second Amendment challenge was in McDonald versus City of Chicago in 2010, where this court held that an individual's right to defend themselves with a firearm in their homes is a fundamental right. And albeit that this court has never adopted a scrutiny analysis to determine whether or not a law violates the Second Amendment, lower courts have relied upon such analysis. And particularly, out of the Ninth Circuit in United States versus Chauvin provides a framework in which the level of scrutiny to be applied depends on two factors. First, whether there's a burden on the core right of the Second Amendment. And second, if there is a burden on the core right and that burden is severe, then strict scrutiny is warranted. And onto that first factor, the core right. This court held in District of Columbia versus Heller in 2008 at the core right of the Second Amendment is the right of law-abiding, responsible individuals. Here, Your Honor, undocumented persons are in fact law-abiding, responsible individuals. As stated on pages 25 to 27 of the record, Dr. Nunez, who's an expert witness and expertise in migration studies, stated that undocumented persons are in fact more law-abiding than American citizens, and particularly regarding violent crimes such as sex crimes, homicide, and property crimes. In category after category, undocumented persons are more law-abiding than American citizens. And specifically, as applied to Eric Cho here in the case at bar, Your Honor, is that undocumented persons, specifically Eric Cho, has never broken the law. Eric Cho.
Counselor, may I interrupt you really quick and ask, if we disagree with the analysis from the Heller opinion, and we instead just decide to apply intermediate scrutiny, do you lose?
No, Your Honor. The petitioner would not fail today, even if this court does apply intermediate scrutiny. And the reason why is because in achieving this statute, the government must not only show a substantial interest, but that is a reasonable fit in achieving this interest. Your Honor, the government's purported interest of public safety is that undocumented persons are presumptively risky, that they're a threat. However, within the record, by Dr. Nunez states that undocumented persons are more law-abiding than American citizens. Therefore, enacting a statute that would prevent law-abiding individuals such as Eric Cho is not reasonable to achieving its purpose of protecting public safety and keeping firearms out of those who are a threat when these individuals are in fact law-abiding. And here, Your Honor, Eric Cho is in fact a law-abiding individual. He has never broken the law. And particularly, Your Honor, the government has argued in the proceedings below at the mere fact that an undocumented person has unlawful status, that is a per se, by definition, not law-abiding. However, that is inconsistent with this court held in Arizona versus United States in 2012, where this court held, as a general rule, it is not a crime for an undocumented person to remain present in the United States. And yes, Your Honor, undocumented persons do cross the border unlawfully, which is a misdemeanor, but that in and of itself does not disqualify an individual from not being a part of a law.
To what extent should this court consider the length of time that an individual is present in the United States illegally?
Regarding whether or not that makes them a law-abiding individual, Your Honor?
Well, to the extent that Mr. Cho specifically was in the United States illegally for quite some time, 17 years, I believe, shouldn't this length of time make a difference, or does it in our analysis?
No, Your Honor, it should not make a difference. First, Eric Cho became undocumented at the age of 5 due to his parents. And therefore, holding that against Cho would not be proper. In fact, what this court held in Plyler versus Doe is that condemnation on the head of a child is illogical and unjust. And second, regarding whether or not Eric Cho should have and had the time to alter his status, that is not what makes an individual a law-abiding, responsible person to possess the core right. And particularly out of the DC Circuit in 2015 in Heller versus District of Columbia. And what the DC Circuit held is that responsible means a person who is no more dangerous than a firearm than that of American citizen. Therefore, Your Honor, this court should not give any weight to the mere fact that undocumented persons, and particularly Eric Cho, has unlawful status. Therefore, Your Honor, because Eric Cho has never broken the law and is in fact a law-abiding, responsible individual, that this court should note that undocumented persons, just like Eric Cho, have the core right of the Second Amendment. And because core of the undocumented persons and Eric Cho have the core right, and now addressing the second factor, is that this law places a severe burden on this core right. Here, Your Honor, the statute 922G5 punishes Eric Cho from possessing a firearm. He's not able to possess any firearm, even the most preferred firearm, the handgun, to protect not only his home, but also his wife. Cho was involved in an altercation that required him to exercise his core right of the Second Amendment to protect himself. And what this statute does is places a severe burden by punishing him, by putting him for prosecutorial charges, putting him in jail for exercising his Second Amendment right.
But Counselor, wouldn't you concede that the US government has a compelling interest in enforcing its laws?
Yes, Your Honor. Petitioner acknowledges that the government does have a compelling interest in enforcing laws, and public safety is a compelling interest. However, if this court were to utilize a strict scrutiny analysis, the government would have to show that this statute is achieving its purpose in the least restrictive means. And specifically, Your Honor, this statute, which places a severe burden on Cho, which punishes him, is what merits strict scrutiny. Therefore, Your Honor, because Cho and other undocumented persons possess the core right of the Second Amendment, because they are in fact law-abiding, responsible individuals, and that this statute places a severe burden on Cho, that the statute merits strict scrutiny. And on to the second area of analysis, that under a
Mr. Barron, with regard to law abiding, so if we disagree with you that unauthorized immigrants or who are here in the United States without authorization are not law abiding citizens, do you think our analysis should be different with regard to DACA recipients?
Yes, Your Honor, in two parts. So first, if this court does hold that in general under a facial challenge, that undocumented persons are not law-abiding because they do not have lawful status, then the petition would point to the stronger argument, and where this court should actually focus more on is that DACA recipients like Eric Cho are in fact law-abiding. Your Honor, the government, by giving Eric Cho and other DACA recipients these protections, concede that these individuals are law-abiding. DACA recipients are heavily vetted, Your Honors, in which the government, in ensuring that they have lawful protections, automatically concede the fact that these individuals are not a threat. And particularly regarding to the strict scrutiny analysis, Your Honor, the government must show that the statute not only has a compelling interest, but be the least restrictive means. And now the petitioner acknowledges the compelling interest. But this statute is not the least restrictive means, Your Honor. It is because the statute is overbroad in nature, in which it sweeps law-abiding individuals such as Eric Cho and other DACA recipients who are not a threat. This is comparable to what this court held in Holt versus Hobb in 2015.
Mr. Barron, if I could interrupt you for a moment, is there a way that you see that this statute could be more narrowly tailored to meet the government's objectives?
Yes, Your Honor. By striking out the provision of 922G5, which classifies individuals as a threat by their mere unlawful status, is what should not be part of the statute. 922G1 through 9 already provide and covers undocumented persons who would and are in fact not law-abiding. Specifically, 922G1, which those who are domestic violent offenders, which is a violent offense. Furthermore, within the statute, those who are felons, those who commit other violent offenses, not just those who are undocumented. That because the mere fact that an undocumented person has unlawful status, and that is not narrowly tailored. Merely requiring an individual to classify them as a threat by their unlawful status is not the least restrictive means.
Counselor, I see that we only have a few seconds left, but I'm troubled by the separation of powers issue that I see here. Isn't this an issue that we should abstain from deciding and leave to Congress to remedy?
Chief Justice, I see my time is expiring. My answer, Associate Justice question.
You may, thank you.
Your Honor, the reason why this court should not leave it to the government is because it is the duty of this as a court to uphold constitutional rights. And specifically, this court held in Heller that under any standard of scrutiny that this court has applied to constitutional enumerated rights, banning a handgun, a firearm, for the protection of one's home would fail constitutional muster. And it's for these reasons we ask this court to reverse. Thank you.
Thank you, Counselor. Ms. Marichalad, you have 2 minutes for rebuttal.
Rebuttal happens, I think, after the respondent.
My colleague is correct in correcting me, so Counselor, you may proceed.
Thank you, Chief Justice Martinez. Madam Chief Justice Martinez, may it please the court. My name is Catherine Cantu, and I, along with Ms. Daisy Ramirez, represent the respondent, the United States of America. Your Honors, there are two issues on appeal today from the 15th Circuit. I will be addressing the first issue regarding the fact that aliens unlawfully or illegally in the United States are not among the people of the Second Amendment and thus are not guaranteed the protections of the Second Amendment. My co-counsel, Ms. Ramirez, will be addressing the second issue and will demonstrate that Title 18, United States Code, Section 922G5, merits intermediate scrutiny, and further, that it is constitutional on its face and as applied to petitioner Mr. Suwon Woo Eric Cho under any level of heightened scrutiny. Your Honors, this court should find in favor of the government because aliens unlawfully or illegally in the United States are not among the people of the Second Amendment for the following three reasons. First, illegal aliens are not members of the political community, thus making them ineligible for the protections of the Second Amendment. Second, illegal aliens are not among the law-abiding responsible citizens that are guaranteed the protections of the Second Amendment. And third, and finally, petitioner's argument that a sufficient connections test should be employed to determine whether Mr. Cho is among the people is not applicable in the Second Amendment matter. Your Honors, this brings me to the first reason why illegal aliens are not among the people of the Second Amendment. Your Honors, this court has already defined who the people are in context of the Second Amendment. In District of Columbia versus Heller, this court stated that the term the people must unambiguously refer to those members of a political community, not an unspecified subset. Thus, when petitioner brings up the test utilizing United States versus Verdugo Aguiles, wherein the court called it a national community, petitioner fails to mention that this court reformulated the term national community into that of a political community, an implication which does change the scope of those who may be protected by the Second Amendment. The political
Counselor, may I interrupt you really fast? So, I mean, I understand that the defendant here has paid taxes, yes?
Yes, Justice Watkins, Mr. Cho has paid taxes.
Established a business.
Yes.
Followed all other laws for the last 17 years. So how does he not meet that definition of the people? Isn't he exactly the kind of people that we want to guarantee constitutional rights to?
Respectfully, no, Justice Watkins. Mr. Cho, although he has paid taxes, has started a business, and has done various other things while in the United States, he has done so knowingly and purposely within this country, unlawfully or illegally. Despite any type of community involvement, that does not change the fact that he does not possess rights of a political nature, which is one of the requirements for an individual to be protected by the Second Amendment. When we look to what the political reformulation suggests, it means that those who are protected by the Second Amendment are those who already possess rights of a political nature, such as voting, office holding, or jury service. Rights that we see are enumerated throughout the United States Constitution, applying to those who are able to possess those political rights and able to possess the right to bear arms of the Second Amendment. Further, Your Honors, Professor and scholar Akil Riedemar best explains that at the time of the founding, the right to bear arms stood shoulder to shoulder with the right to vote. Arms bearing and militias embodied a paradigmatic right, flanking the other main political rights, such as voting, office holding, or jury service. Further, after a thorough analysis in the Fourth Circuit in United States versus Carpio Leon, the court concluded the historical evidence produced by this court in District of Columbia versus Heller suggested and supported the notion that the government is constitutionally permitted to prohibit the use of firearms for those individuals who are not among the law-abiding, responsible members of a political community. Further, Your Honors. Yes, Chief Justice Martinez.
The government then suggests that we should see or view the language both of the preamble, the entire Constitution, in the context of this statute, to suggest that as long as there's a different purpose, it justifies interpreting the amendment separately, almost as a means to an end. The government would suggest that we could justify, the courts could justify different readings of, quote, the people, and in one case, reading it to achieve broad protective goals for its persons, in the United States, while reading it narrowly in the Second Amendment simply to acknowledge gun rights, which may have political connotations. Yet in reading the Second Amendment and various others, let's take just the Second Amendment. There's no distinction the government would concede, that there's no exception rather to make the right of the people to keep and bear arms, no exception to just citizens, just recognized individuals. No other demographic is excluded within that right or in the definition of the people, which is in the first sentence of the Constitution in its preamble. How would you suggest the courts make that distinction?
Chief Justice Martinez, to answer your question, we see that the different rights are different in kind. So when we compare specifically the Second Amendment to, say, the Fourth Amendment, we see that the Second Amendment is an affirmative right at its core, whereas the Fourth Amendment is a protective right, a distinction that was recognized by the Fifth Circuit in United States versus Portillo Munoz, wherein the court also analyzed the same statute we consider today and also analyzed whether or not an alien who was unlawfully or illegally in the United States was among the people. The Fifth Circuit concluded that they were not only because they were not law-abiding nor members of a political community, but also because the rights are different in kind, the Second Amendment being that of an affirmative right. So when we look to affirmative rights, we also see that other affirmative rights within the United States Constitution include those within Amendments 15, 19, 24, 26, the right to vote, Articles Section 1, Articles 1 and 3, the right to run for office. So all of these are affirmative in nature, which does imply the narrowing of within those who would fall the scope of the Second Amendment. So also utilizing this court's language in District of Columbia versus Heller, we see that if undocumented immigrants, those who are not members of a political community, cannot be protected under the Second Amendment, there's also another reason provided by this court in Heller to say that the Second Amendment right belongs to that of law-abiding responsible citizens. And to answer your question once again, Chief Justice Martinez, while the term citizen is not utilized exactly and explicitly in the Second Amendment, the implications by this court do show that an individual not only must be a member of a political community, but also must be law-abiding, responsible, and a citizen to be guaranteed the protections of the Second Amendment.
So if we go with law-abiding citizen to decide who has a right to a Second Amendment, or who is, whether Mr. Cho falls within the people definition, then if that's the standard we use, or one of them, wouldn't someone, a native born with a rap sheet who's not a felon, have more rights than a DACA recipient who has been law-abiding for all intents and purposes? And would that be, do you think that's constitutional?
Yes, Justice Rios, that is constitutional because we see that there is a ascending scale of rights. So those undocumented immigrants who start at the very lowest level with no rights guaranteed because they are in this country unlawfully or illegally. And then as we move up within the scale, individuals are guaranteed more rights as they become different types of members of the society of the United States of America. That does change. However, the fact remains true that aliens who are unlawfully or illegally in the United States, including DACA recipients, are not those who are guaranteed the rights of the Second Amendment. Specifically, because a person is entitled to DACA relief, that does not change the fact that they are still considered as an alien who was unlawfully or illegally in the United States. This issue was considered in the Fifth Circuit and the Sixth Circuit, specifically in United States versus Lopez, wherein the court found that DACA relief entitled no substantive rights to unlawful aliens, no type of immigration change, no type of pathway to citizenship. Thus, DACA recipients, and Mr. Cho specifically, are not among the people of the Second Amendment because they remain aliens who are unlawfully and illegally in this country, a violation of the laws of this nation.
Ms. Kanthu, just really quickly, I know you're running out of time, but I'd ask leave from the chief on this. Does the fact that he is in the process of obtaining his green card change your analysis at all? He really, for all practical purposes, has done everything that he is required to do, and perhaps his application is being held up through no fault of his own. Does that change your analysis at all? And again, I'd ask the chief if she would grant Ms. Cantu a few moments to respond.
You're free to answer and close, counsel.
Thank you, Chief Justice Martinez. Justice Rodriguez, to answer your question, no, unfortunately, any type of process for the application of adjustment of status, which Mr. Cho is currently involved in, does not change his legal status. Specifically, we look to the Fifth Circuit in United States versus El Rari, which stated that an application for adjustment of status does not confer any type of change to an alien's lawful status. Thus, Mr. Cho, while he has taken the affirmative steps to change his status to obtain a green card, is still within the category of an alien who is unlawfully and illegally in the United States, thus making him a person who is not a member of the political community, who is not a law-abiding responsible citizen, and thus who ultimately does not possess any protections under the Second Amendment. Your Honors, for the foregoing reasons, the government prays that this court affirm the holding of the 15th Circuit and finds that aliens who are unlawfully and illegally in the United States are not among the people. Thank you.
Thank you, counsel. You may proceed, counsel.
Madam Chief Justice Martinez, my name is Daisy Ramirez, and I too represent the respondent, the United States of America, in the present appeal. Today, I will be addressing the remaining issues before the court that this court should apply intermediate scrutiny to Mr. Cho's Second Amendment challenges of Section 922G5 on its face and as applied to him, and that under such scrutiny, the statute is still constitutional. Your Honors, should this court decide today to answer the first question in the affirmative, that illegal aliens are among the people protected by the Second Amendment, the statute still merits intermediate scrutiny because it does not severely burden the core right of the Second Amendment. This court in District of Columbia versus Heller stated that the core right of the Second Amendment are the rights of law-abiding, responsible citizens to use arms in defense of hearth and home. However, as the Fourth Circuit in United States versus Chester held, this right is not unlimited, and Congress may impose certain limits as to where the right is exercised, how the right is exercised, and who may exercise this right. Illegal aliens, including Mr. Cho, are neither law-abiding nor citizens of this country, and therefore their alleged right to possess firearms is not at the core of the Second Amendment. Your Honors, the statute merits intermediate scrutiny for the following two reasons. First, though this court has declined to apply an exact standard of scrutiny to Second Amendment challenges, circuit courts have universally applied intermediate scrutiny to challenges made by United States citizens themselves and to challenges made by illegal aliens to Section 922G5 specifically. The Ninth Circuit in United States versus Torres held that the burden imposed by the statute was tempered and therefore not a severe burden. Further, the Seventh Circuit in United States versus Mesa Rodriguez also held that the statute merited intermediate scrutiny because illegal aliens are neither law-abiding nor citizens of this country. Therefore, Your Honors, the unanimous jurisprudential understanding is that intermediate scrutiny is appropriate for this challenge. Second, the reason the statute merits intermediate scrutiny is because it is not a severe or even substantial burden on the core right of the Second Amendment. The third.
May I interrupt you before you go into your next point? Is there any case you can point us to, any authority that has actually decided a case regarding DACA recipients and not just illegal immigrants in a broader group?
Justice Rios, yes, the Fifth Circuit in United States versus Arrieta heard a similar case as we're hearing today by a DACA recipient challenging the statute of Section 922G5. There, the Fifth Circuit found that although recipients with DACA status underwent a rigorous application process and have been deemed that they don't possess a threat to public safety, the matter of the fact remains, and as the Fifth Circuit held, they are still individuals who are in our country without any legal status, and they are not citizens, and therefore they do not have rights under the Second Amendment. And in another case, the Fifth Circuit versus the Fifth Circuit in United States versus Torres also held that DACA recipients are simply not citizens of this country. And although they do have DACA status, it does not convey or alter any substantive immigration right. And while they are granted rights to work in this country, they're still subject to deportation and may be removed from our country at any time.
Counsel, how do you mesh, well, you consider the undocumented individual a felon by the mere fact that they're here undocumented. Is that accurate?
Chief Justice Martinez, being in this country undocumented is not a felony, but their mere presence in this country is contrary to our laws, and they do evade detection and live in the shadows of our nation. So
But our laws actually give a path. They provide a path for an individual. Mr. Cho was going down that path and was essentially at the gate to receive that. What interest does the government have in providing a path, but then putting an obstacle right in front of it without, what interest would that be? What interest does the government serve in basically putting up that obstacle on its own in the path it creates? And for all intents and purposes, an individual who follows that path, abides by the traffic signs, yields when he has to, stops when he has to, but right at the end, he's deprived of it. What interest and where in the Constitution or in our laws permit that by the government?
Chief Justice Martinez, to answer your question, while the government recognizes that the pathway to citizenship or residency in our country is not an easy task, and it's often complex and lengthy, unfortunately, this does not minimize the fact that such pathways to citizenship exist, and therefore the right is not, the burden placed by the statute is tempered. And further, although Mr. Cho may be an exemplary student, may have DACA status, and may have been in the application process for residency on November 15, 2017, the facts remain true that Mr. DACA, on the date of his arrest and as he stands here today, is still an alien illegally in our country. And the courts owe Congress deference when making laws related to immigration matters. Congress has decided that the line to be drawn was at immigration status. And while the pathway to obtaining immigration status might be difficult, the fact remains true that illegal aliens are simply not citizens, and they still evade detection. And Mr. Cho's application status may nonetheless be rejected, and he may be placed in deportation proceedings. So the mere fact that he was in the adjustment of status process, that his application was pending, that he had DACA relief, it does not convey any substantive immigration right, and he was still illegally in our country. And the government has an interest in ensuring the public safety because these individuals are simply untraceable and undetectable. And as the Seventh Circuit in United States versus Mesa Rodriguez held, illegal aliens live largely outside the formal systems of registration, identification, and employment, and they're more likely to assume false identities. So, Your Honor.
Is there evidence in the record of that? And even if there was, certainly the trier of fact would convey that, but in the claim that's before us right now, and reading the material you've provided, the government, which in all its actions seeks to preserve the spirit that is contained within our founding documents, the Constitution, the first words of which are "we the people of the United States." In order to form a more perfect union, establish justice. Mr. Cho's becoming a gladiator in the arena of justice by going to law school, ensure domestic tranquility. He is eligible as an immigrant to serve in the military, to provide for the common defense, as my father did, who was actually an immigrant, undocumented before, and yet still serving in the Navy, as any DACA or Dreamer is entitled to do now. Promote the general welfare, he's employed, pays taxes, and secure the blessings of liberty to ourselves and our posterity. For all intents and purposes, there is no indication, unless you can point to, that documentation of an individual, that citizenship was required to enjoy the freedoms and liberties provided under our founding documents. How would you respond to that argument? I suspect is what the petitioner is also making in its claim.
Chief Justice Martinez, to answer your question, The purpose of enacting Section 1982G5 was to keep instruments of deadly force out of the hands of those deemed dangerous, irresponsible, or presumptively risky people. Congress, when they enacted Section 1982G5, as they did with the other sections of 922G, made the determination that illegal aliens in this country are simply presumptively risky people because they just live in the shadows of our nation. They go undetected and evade detection. And therefore, just as they prohibited those that are mentally ill or those who were disarmed from the armed forces for dishonorable conduct or those who abuse drugs, though these people may not per se be inherently dangerous, they are simply a class of presumptively risky people that should not be armed.
Well, in this case, we have, protecting immigrants without authorization in the United States under all three amendments would protect American citizen right holders, right? So would it be then a difference is if he was using a gun to protect his threshold, his household, which would, for all intents and purposes, may contain citizens in his house? Do we then make a distinction about whether or not he's protecting his home, those who intrude into his threshold, and then make him someone unworthy of being here in the United States legally because he chooses to protect maybe members of his family? Are we supposed to make distinctions about whether those individuals are or are not also citizens? Is there a bright line to be made by is that what you're asking the courts to do?
Chief Justice Martinez, I see I'm out of time. May I answer?
Please.
To answer your question, while the government recognizes that on November 15, 2017, Mr. Cho possessed a firearm to protect his United States citizen wife and his home against potential danger, the fact of the matter is that the core right of the Second Amendment is that the right belongs to law-abiding, responsible citizens. And although Mr. Cho does meet the second component, that he was defending his hearth and home, on that day, he simply was not a citizen of this country. And while citizens in the home may have this right, their right is not infringed. Mr. Cho was arrested that day for his possession of the firearm, not because he was around it. Therefore, Your Honor, as the statute is written, it is substantially related to the government's interest of ensuring public safety because illegal aliens, including Mr. Cho, whether or not they're in the process of acquiring lawful status, are simply undetectable. And just as the court enacted Section 922K, which prohibits the possession of firearms of obliterated serial numbers, because these guns are simply not traceable, the same reasoning follows Section 922G5, which prohibits possession of firearms by individuals who are simply not traceable. Your Honors, for the foregoing reasons, the government prays that this court affirms the judgment of the United States Court of Appeals for the 15th Circuit and finds that the statute is constitutional. Thank you.
Thank you, counsel. Now I invite rebuttal by Mrs. Monticelli. Please proceed.
Thank you, Chief Justice, and may it please the court. For the time I have remaining, I will quickly address 2 points that respondents made. The first is that respondents argue for a political community standard. However, the Heller Court did not define what the political community means. Therefore, we cannot determine who is part of the political community and who is not part of the political community. Respondent relies on implications of what this term can mean. What this court did adopt in the Heller decision was the definition of the people as used in the case of United States versus Verdugo Urquidez, which held that the people are those who are part of the national community or those who have sufficient connections to the country. And Cho clearly shows that he does, and therefore he must be considered part of the people using this standard. The second point is that respondents argue that people like Cho who are undocumented cannot be tracked and therefore should not be granted Second Amendment protection. However, Eric Cho is a DACA recipient. DACA recipients are different in that they can be tracked. they're able to obtain employment and they're able to further their education. The fact that they can be tracked does not make them dangerous to society. And the government has conceded that DACA recipients are law-abiding in that they've granted them DACA protection, because a prerequisite for DACA is the finding that they pose no threat to society, that they have no serious misdemeanors, and that they have committed no felonies. Further, as Chief Justice Martinez asked opposing counsel whether the government makes pathway to citizenship difficult, the answer is that it does, extremely so. Eric Cho applied for DACA and applied for permanent residency. We are here today because Eric Cho did not hear back from whether or not he was granted permanent residency. Therefore, the government does place obstacles for undocumented people to be part of the society. Therefore, we ask this court to rule in favor of petitioner. Thank you.
Thank you, counsel. The case is being submitted to the court for consideration. The court will now stand in recess for deliberation. We'll return momentarily with a decision. Thank you.
All right, good morning, everyone. That was a great argument. I really enjoyed it. I believe some of you might be wondering how many times I'm going to come on screen during the argument. I don't know why my computer was doing that. I really don't. We had a fantastic round, but we had many more rounds that happened before this. I'm AJ Belito-DeLuna. I am the Director of Advocacy here at St. Mary's, and I'm the faculty advisor for our Board of Advocates. This year, Meredith Knox and Noah Warren, they were the co-chairs of this year's competition. And it was a big challenge because it was online and we had never done that in-house. We had over 250, it was 256 rounds of competition that they had to arrange for. And that was quite a lot. So I want to extend my gratitude to Meredith and Noah, and there's a lot of people that are behind them that are have worked really hard to bring this on, as well as all of our faculty, our coaches, our judges. Thank you, everybody, for all that you have done. I think at this time, Meredith, if you can share you can go ahead and put up the PowerPoint. We'd like to go ahead and acknowledge all of the students who advanced during the preliminary rounds.
All right, good morning, everyone. I'm Meredith Knox, and I was co-chair of this competition, and I would just like to take the time to congratulate all of our octo finalists, Tristan Spencer and James Toy, Roberto Ceballos and Ronaldo Elizondo, Laura Flores and Isabel Campos, Caroline Henry and Caitlin Hennessy, Philip Erickson and Miguel Gutierrez, Alexander Parker and Josh Espita, Kimberly Lee and Karen Crawford, Gabriela Saldana and Courtney Schrader, Gregory McEwen and Eric Schultz, Heather Montoya and Victoria Malie, Yamaleth Vasquez and Genesis Salinas,
Nash Noel and Ryan Nagel, Leanne Greenberg and Miles Gavas, Jessica Henry and Joshua Johnston, Kyle Baston and Dom Alves, Cairo Falcon and Bailey Ferguson, Catherine Sams and Amy Russo, Jade Smith and Sabrina Gonzalez, Maria N. Jaimes and Gabriela Iverson, Justin Rorick and Stephanie Thompson, Christian Ramon and Casey Dunn, and Caitlin Holscher and Allie Heinminer.
Congratulations to the quarterfinalists, Cody Kent and Kristen Roberts, Haley Harvey and Maya Henry, Julia Awad and Alexandra Garza, Ryan Vereen and Ronnie Wilkins.
Congratulations to the semifinalists, Jared Hall and Charles Garcia, and Syrian Jones and Sarah Borland.
Last, we'd really like to take a special moment and thank our sponsors. The board extends its sincerest appreciation to Linda and Dave Schlueter for their ongoing sponsorship of this competition.
The board would also like to thank the law firm of Jackson Walker LLP for its generous contribution in honor of Charles Smith.
And additionally, the board thanks Margaret Maisel of the Law Offices of Margaret Maisel PC for her monetary award to the finalists of this competition, and David McQuaid Lebowitz of David McQuaid Lebowitz PC for his contribution to the Best Advocate Award. Thank you everyone for your help throughout this competition.
Thank you, Meredith, and thank you, Noah, and thank you, Mr. Leibowitz, for your contributions. We appreciate you. If I could please ask Liz Dugan and Professor Cavanaugh to come on screen. All right, Elizabeth, I want to thank you for all the hard work that you have done on behalf of the Board of Advocates. This is the end, coming to the end of your 2 years. You have been a leader since day one, but it is time to pass the torch. I'm sure there's a part of you that loves that and a part of you that is sad to see that go in both ends. But thank you for your leadership. Thank you for all of your support, not just to our students, but to students all over the country. Thousands of students have had the opportunity to compete this year thanks to your leadership. And that's something that I will just never forget. So thank you. And I want to send a special thank you to Professor Cavanaugh. Professor Cavanaugh is our Law Success Program. And he and his instructors have been just amazing from the very beginning. We wanted to make sure that we gave our 1Ls an experience. It wasn't live like we wanted to, but he and I worked together along with the board, and we were able to bring this experience this year to these students, something unfortunately that our current 2Ls did not have. So thank you, Professor Cavanaugh, for your help and your leadership. And now it's time to pass the torch for the executive board. And I'm here to announce the executive board for 2021-2022. Our new chair for next year will be Miss Meredith Knox. She's going to be our new chair. You can kind of click again, please. Our new vice chairs are going to be Brooke Baumgardner, and then Karen Wieters is going to be our vice chair for alumni relations. Our secretary will be Mr. Noah Warren. Stafford Sadler is our treasurer, and Emily Fay will be our historian. I'm also announcing today by special appointment, Ms. Jasleen Shokar is taking the responsibility of becoming our first ever recruitment officer. With the help of Ms. Shokar, we hope to further engage students, especially students of color, into the national team and the Board of Advocates. We want to reach out, and Ms. Jasleen Shokar has taken the special assignment, and I want to thank her. I want to thank the entire executive board for what you're about to embark on in the next year. You have big shoes to fill, but I know that you'll be able to do that. And don't lose Elizabeth's phone number. And I think that's it. I do want to just remind everybody that the national team tryouts are taking place. They start yesterday. They go through April 28th. This will include the Board of Advocates, the ADR team, the trial team, the Jessup team, and the St. Mary's Moot Court team. These are all special opportunities for all of our students, and we hope that we can continue what we've been able to do so far with you. For now, we're going to stand by and we're going to wait for the court to come back and render their decision. I want to congratulate these students on a fantastic round. Thank you.
It is still good morning. Good morning, everyone. Thank you very much for those in attendance. Thank you to the competitors, advocates, I'll refer to you better. We are delighted to have been invited to judge the final rounds of the 1L Moot Court competition here at St. Mary's University. As always, as is tradition, we would be there with you in person. Regrettably, we can only look forward to possibly next year and enjoying an in-person argument. Before I begin with, or before I announce the winners of the Best Advocate and winning team, I'd like to introduce the members of the Fourth Court of Appeals. I am Chief Justice Rebecca Martinez. Justice Patricia Alvarez was unable to join us today. Justice Luz Elena Chapa is present. Justice Irene Rios is here with us today. Justice Beth Watkins. Justice Lisa Rodriguez. And our newest member of the court, Justice Lori Valenzuela. Again, we express our gratitude in being able to be here with you today. Dean Roberts, thank you very much for allowing us to continue this tradition on a virtual platform. And then, and of course, thank you to all of the St. Mary's students who have participated in this competition since day one. We congratulate all of the participants of the competition, and in particular those members who are here in the final round with us. I see no one else on the screen except us, and I invite everyone to return. Very good. Correct me if I'm wrong, but I'll announce the advocates in the order of their appearance. Ms. Brenda Marichalar and Josue Barron for the petitioners. Job well done. And for the government, I believe the first arbiter was Catherine Cantu. Is that correct? Followed by Daisy Ramirez for the government. Well done, advocates. At this time, I will announce the winning team. Again, as a reminder, we are not commenting on the subject matter of the case, nor are we making a determination of who would ultimately win the argument based on law and facts of the case, since we are in a kind of a pretend Supreme Court. But however, in judging the advocacy skills of all of the competitors, we would like to say that it was a difficult task. We could probably spend quite a bit more time deliberating between the teams. Both of the teams have excelled in their training at the university, at the law school, and we look forward to seeing a lot more acrylics on your desk for all of the competitions that I'm sure you will enter and win. So congratulations again. The winning team this morning will be the advocates representing the government, Ms. Cantu and Ms. Ramirez. Congratulations to you. And the best advocate, the court has decided is Ms. Catherine Cantu. Congratulations. And we again look forward to seeing you and becoming members of the bar and sister and brother colleagues to the Texas State Bar maybe. And we look forward to your successes in the, as gladiators, as I said, in the justice arena, becoming lawyers. And we are all proud of you. With that, I would like to invite the dean if she wishes to make any comments or to moderate any questions that the advocates may have. Again, at this time, we'd have recessed the court, come down to the floor and congratulate you individually in person. Before we depart, we hope that we'll be able to take a nice little screenshot for posterity as well with the members of the team And again, congratulations. I'll invite any of the members of the court as well to make any comments, and I'll invite Justice Chapa first.
I will be brief because my connection is so poor. I apologize to everyone for my connection. I was getting kicked off and on throughout. So first and foremost, thank you to St. Mary's School of Law. It's wonderful to be here with you again today. And I'm glad we were able to get this done virtually. And we miss being in person, but we hope to be back next school year. Congratulations to the 4 competitors. You all make us so proud. You are our hope and promise for the legal profession. And I encourage you to keep going and encourage each other, support one another. And I know that you will continue to do great things. Congratulations to the 4 of you.
And I'll go next. I want to say that all 4 of you were excellent. You did an outstanding job. This was a very close final round. So I hope all 4 of you, including Ms. Marichalad, Mr. Barron, please, I hope you do not walk away from this disappointed. All 4 of you have accomplished an incredible task. You have beat out so many teams. You know how many started. When I was in law school, I think there were maybe 60 some teams. I don't quite remember anymore, but there are probably more. So for you to be the last 4 duking it out in the final round, you should be very, very proud. And I am just so impressed with your advocacy skills. And if this is where you are, because we've witnessed it at the end of your first year, you've got a very, very proud and bright future as advocates. So continue to work hard. And I look forward to seeing you begin your legal careers in a couple of years and follow your careers. So congratulations. I'm very proud of St. Mary's with the advocates that they're producing, and very proud of all 4 of you.
Good morning, everyone. I am delighted to see such fantastic, and not at all surprised to see such fantastic advocates coming from St. Mary's. The 4 of you are truly extraordinary, and I cannot believe that you are first-year law students. If you were to come to the courthouse right now and argue a real case in front of us, I have no doubt that you would just smoke all of the practicing lawyers out there. Just a few quick compliments and my highest praise. Ms. Marichalad, I'm so sorry, I'm butchering your name. You had extraordinary poise and time management skills. I mean, I could tell that you were keeping an eye on the clock, and your comments you fit them in perfectly in the time. That is an exceptionally difficult thing to do. And so kudos to you. Mr. Barron, you did a fantastic job of responding to questions and then seamlessly weaving back into your argument. It was exceptionally well done, and I'm thoroughly impressed. Ms. Cantu, I thought you were just incredibly smooth. We had lots of questions for you, and it was not lost that you were having to make an argument that the people should equate to the voters in front of a panel of 6 women who would not have qualified as voters in 1791 when the Second Amendment was enacted. You stood up there and you made a hard argument with grace and poise, and I think you did so extraordinarily well. So my compliments to you. And Ms. Ramirez, you knocked my socks off. You were so good. We had so many questions for you, and you just seamlessly, again, answered them and worked your way back into your argument. Didn't even bat an eyelash. My hat is off to all 4 of you for a job very well done.
I'll go next. Good morning, and thank you, St. Mary's, for giving us this amazing opportunity to judge these incredible students. What can I say? You all are amazing first-year students. Your advocacy skills are just so impressive. And the poise and professionalism you show is truly extraordinary. So I want to thank you for the opportunity to participate in judging you. You each have such excellent advocacy skills, and I truly look forward to seeing where your career takes you. Thank you, and congratulations to all of you for a job very well done. Thank you.
Good morning. Thank you, St. Mary's, for hosting us, and thank you for letting us be a part of this beautiful day. This, having just joined the court, is my first oral argument, and I will say I am not disappointed. The four of you did an excellent job, and I would suggest to you that your ability to answer the questions and jump right back into your argument and do it seamlessly was truly impressive. So I look forward to seeing you all in a few years, and we'll continue to watch your careers, because at this stage of the game, if you're doing this as first-year law students, I cannot even imagine where you will be a few years from now. So thank you for allowing me to enjoy this day and to enjoy this first oral argument. It was absolutely top-notch. So excellent job, the four of you. Congratulations.
Thanks again on behalf of the Fourth Court of Appeals. I would also like to acknowledge the new board advocates, new board of directors. Congratulations to you. We look forward to your continued leadership, as well as to the other awardees that were announced earlier. So again, congratulations to everyone, and we look forward to next year's competition. At this time, I'll invite the dean to make final remarks, or anyone else, and then we can, Michael Cruz, our clerk of court, can then end the recording. However, we will continue after the recording is stopped to be posted on the live stream of the Fourth Court of Appeals. I invite everyone to subscribe. That recording will be archived and maintained there for in perpetuity, so you can come back and enjoy your performance. Maybe come back and self-critique if you'd like for future competitions, but we look forward also to viewing them among the future competitions as they are archived on the Fourth Court of Appeals new YouTube channel. Who'd have thunk that we have one now? So again, congratulations to all of you, and I'll hand it to Dean Roberts for final remarks, and then we'll stick around for a nice photo op. Thank you, Dean.
Thank you so much.
I'm sorry, forgive me. Last but not least, I would like to acknowledge the Schlueters, Linda and David Schlueter, who are the sponsors of this competition. I would be remiss to avoid neglecting to acknowledge them. We always look forward to seeing our hosts, the Schlueters, in person while at the law school, and we look forward to seeing them again. So thank you very much. Our gratitude to them for allowing us to participate in the competition, and for their generosity to the St. Mary's University, who of course continue to enjoy the benefits of, I'm the odd woman out, but every member of the court present here today is a proud St. Mary's Law School alum. And so we hope maybe one day to see one or all of you continuing your service after the bar and onto the bench. So thank you, Dean Roberts.
Thank you so much, Madam Chief Justice, and thank you to the fellow justices and our dear alumni, members of our St. Mary's family. I want to congratulate the advocates. You have made us so proud, really. Outstanding job today, truly exceptional arguments. I agree with all that the justices have said about your performances, and I do want to congratulate all of the competitors. And ultimately, Ms. Cantu, well done in being the top arguer in this competition. And congratulations to the new executive board of the Board of Advocates. You have big shoes to follow, but I know that you will do it. And I'm going to conclude by saying just thank you for watching today, and we look forward to doing this next year in person.